Be ready. 5 seconds.
Learned counsel for the appellant submitted that he has been subjected to unfair treatment by the tribunal as though he had entered appearance upon notice, one opportunity was required to be given to him since he was faced with serious penal consequences like detention and slash or deportation from the country, which was not done. Stop. Even the medical certificate, which is disputed, has been issued by the consultant of the hospital, who was never examined. Stop para. It was submitted that the High Court has erroneously presumed that the ground for not appearing before the tribunal was not genuine. Stop. Learned counsel contended that even if, for the sake of argument, it is presumed that the reason for his absence was not genuine, it cannot take away the basic fundamental right of the appellant to be heard, that too in such an important case, where the appellant stood not only to lose his nationality but also separation from his family and possible deportation to a foreign state which would obviously not accept him because he was born in India, and thus, there was no occasion for any foreign country to accept him as its citizen. Stop para. Per contra, learned counsel for the state of Assam submitted that the present was a case of illegal migration of a Bangladeshi national to India after the cutoff date of 25/3/1971 and has to be dealt with utmost caution, considering the adverse consequence of illegal migration on the whole country in general and the respondent state in particular. Stop. It was further submitted that the present proceedings against the appellant have been initiated under the Act, which under Section 9 provides that the onus is on the person proceeded against slash alleged foreigner to prove that he is not a foreigner. Stop para. Having considered the matter, the court finds that grave miscarriage of justice has occasioned in the instant case. Stop. The appellant is not a foreigner recognized as a national by the law of more than one foreign country. Stop. Thus, the appellant's case would not fall under Section 8 of the Act. Stop. That being the position as regards Section 8 of the Act, we venture forward. Stop para. From an overall discussion on the report slash opinion of the tribunal, it is clear that there is minor discrepancy in the appellant's documents, however, their authenticity is not in doubt. Stop. In the considered opinion of this court, the same would further buttress the appellant's claim, that not being in the wrong, and being an ignorant person, he, truthfully and faithfully produced the official records as they were in his possession. Stop. We do not see any attempt by the appellant to get his official records prepared without any discrepancy. Stop. The conduct of an illegal migrant would not be so casual. Stop para. This court has found that the inferences drawn by the tribunal do not falsify the appellant's claim. Stop. In view of detailed analysis, the discrepancy in the material produced by the appellant can be termed minor. The same were not sufficient to lead the tribunal to doubt and disbelieve the appellant and the version put forth by him. Thus, we are not inclined to remand the matter to the tribunal for another round of consideration. Putting an authoritative quietus to the issue, the appellant is declared an Indian citizen and not a foreigner. Necessary consequences in law shall follow. The appeal would, accordingly, stand allowed on the aforementioned terms.